Thank you very much. We have taken the appearances. We will straight away go to the petitioner's case.
It may please the court, I'm going to deal with issue number 6 amongst the 9 issues that were crafted by the court for purposes of determination. And yes, and my learned friends, Mr. Firoz Norji, will deal with the issues captured in number 8, 8 and 9. And my learned friend, Mr. Mwangi, will deal with the issue number 6. My learned friend, Mr. Philip Murgor, will deal with the issue number 1, 2, and part of 3. And my learned friend, Ms. Julie Soweto, will deal with the issues 3, 4, 5. I appear together with my colleagues for the first and second petitioners in the consolidated petition. The petition was filed on the 22nd of August this year, following the declaration of the results of the presidential elections that were held in the general elections on the 9th of August 2022. And those results were declared on the 15th of August 2022. Following that declaration, the petitioners, the first and second petitioners, were aggrieved with that announcement and consequently filed this petition. The petition is accompanied with a host of affidavits, and it may please the court, I'll refer to about 5 or 6 affidavits in my address. But as a matter of opening, I would want to deal with some constitutional issues as set out in the various articles of the Constitution. My lords and my ladies, after many years, the Kenyan people came about with the Constitution 2010. They enacted this, the Constitution 2010, and as opposed to the previous occasions, we had a constitution which was enacted by the people, in which they declared their sovereign authority. Therefore, anything done in the name of the Republic, in exercise of powers that spelled out in the Constitution, is based on donated or delegated authority as set out in Article 1 of the Constitution. Now, my lords and my ladies, it is important to put into consideration Article 2 on the supremacy of the Constitution, together with Article 3, which talks about the defense of the Constitution. As opposed to the previous periods when we had a constitution which was negotiated at the time of independence with the colonial authorities, this constitution established a republic in which the doctrine of separation of powers was embedded. And more particularly, my lords and my ladies, in this constitution, there were several constitution bodies and agencies that were created, which includes the first respondent, the Independent Electoral and Boundaries Commission. And in accordance with the dictates of the Constitution, the Independent Electoral and Boundaries Commission, just like any other body established under the Constitution, and for that matter, any person who resides in the Republic of Kenya is required not only to recognize the supremacy of the Constitution, but act in accordance of the Constitution and in defense of the Constitution. Under Article 249, all independent offices and independent commissions are required to respect the sovereignty of the people and also to promote constitutionalism. This is important because Article 249, as read with Article 88 of the Constitution, which vests powers on or to the Independent Electoral and Boundaries Commission, requires that those powers must be exercised in accordance with the Constitution. Now, my lords and my ladies, the story that emerges out of the events that occurred on the 9th of August this year, and subsequently following to the 15th of August, upon the declaration of the Constitution, of the elections, the presidential elections, goes contrary to the established provisions in the Constitution, and will enumerate those violations at the appropriate time. But in opening, I want to say this, my ladies and my lords, that this grievance that we place before you, the highest court in the land, is not just a conspiracy theory. It is not just any ordinary event. If you look at the evidence that is placed before you in totality, we invite your Lordship to come to the conclusion that what happened on the 9th of August this year and the subsequent events that followed on the 15th of August mark a pattern of violations against the Constitution in order to undermine the authority of the sovereign will of the people, and in effect preside, that is the commission, preside over an election that in effect did not represent the will of the people of Kenya. Now, in saying it, taken through a host of evidence borne out in the affidavits that show clearly, just like as laid out in Article, was in accord with the requirements of the Constitution as laid out in Article 81 of the Constitution. Article 81 of the Constitution requires that in the Republic of Kenya should abide by the general principles set out in that article, and more particularly Article 81 Article 81E, and fair, and Roman 4, the elections must be transparent, and Roman 5 of that article, that the election should be administered in an impartial, neutral, efficient, accurate, and accountable manner. My lords and my ladies, I want to emphasize the words accurate and accountable manner. And those provisions in Article 81 read together with Article 86, which requires that at every election, the Independent Electoral Commission shall ensure that whatever voting method that is used, the system is simple, accurate, again, the word accurate, verifiable, secure, accountable, and transparent. And more importantly, that the votes cast are counted, tabulated, and the results announced promptly, and that is at the polling stations. My lords, you would notice that as we appear before you today, we have something that has never happened in this country, that you have a commission that is divided right in the middle. That speaks to a dysfunctional constitutional body that is not capable, leave alone the transgressions that we are going to talk about. But we are talking about an electoral commission that is dysfunctional and cannot be able to preside over an election that would give it the stamp of legality and legitimacy as spelled out in the Constitution. And I think that is a matter that this court should not disregard. And we'll come to that a little later in our address. Indeed, the Tower of Babel has been brought down by the appearance of two factions within the commission before your lordships and my ladies. And this, in event, has created a situation where no Kenyan can believe that the pronouncement of the first, of the ninth, I think the second respondent, Mr. William Samoei Ruto, as president-elect, came out of circumstances as envisioned in the Constitution of the Republic of Kenya. And your lordships, we would invite you, and my learned friends are going to address you on this point as to what really happened within the commission. Now, coming to the subject matter that I'm going to address you on in the question of the issue number 7, that states that the declared president-elect, whether the declared president-elect attained 50% plus 1 vote of all the votes cast in accordance with Article 138, sub-Article 4 of the Constitution. We want to persuade you that the second respondent never attained that constitutional threshold. And going back to the Constitution on that particular article, Article 138, sub-Article 4, it was made part of the Constitution by the framers of the Constitution to give legitimacy to anybody elected as president, to the effect that he had widespread support of the Kenyan people, and that is evidenced by the requirement that the president-elect must have at least 25% of the votes cast in each of the more than half of the counties. We are not dealing with that point. We're dealing with Article 4A, that it is a requirement, mandatory requirement, that the person elected as president must receive more than half of all the votes cast in the election. Now, talking about numbers in those two provisions speaks to the need for accuracy and accountability to give an election the legitimacy that the holder of that office would carry while exercising the powers of the President of the Republic of Kenya. And it's not an idle matter, because we went through an experience before the enactment and proclamation of this constitution, that a person would be elected by way of a simple majority, and in circumstances in which you would find that the person elected as president did not garner more than half the votes which are cast in a presidential election. So this is an important matter. And the difficulty about this particular article is that it requires, at the end of an election before the declaration, that the Commission carries out some mathematics, some mathematical calculation and computation based on proper returns of the votes that were cast in the polling stations and transmitted, as it were, the results thereof to the National Tallying Center and verified accordingly in terms of the Article 38 and the Elections Act. Now, my lords and my ladies, my starting point would be the fact that in this election, it was declared that, and that is found in paragraph 7 of our petition, that the second respondent in the declared result garnered 7,176,141 votes, which according to the Electoral Commission represented 50.49% of the votes cast in the election. Now, this figure would be correct depending on the calculations that were carried out or computation done by the Electoral Commission based on the votes cast during the elections held on the 9th of August 2022. Now, the complaint on this in this particular regard is contained in paragraph 43 to paragraph 47, 48 of the petition. And for purpose of clarity, with your permission, my lords and my ladies, I would want to read out those particular paragraphs of the petition so that I can properly put it in context. Paragraph 43 bars that the number of voters who turned out to vote in the general election held on the 9th of August 2022 remains indeterminate. The second respondent has been issuing contradictory figures on the voter turnout. On the 9th of August 2022, on or about 1600 hours, 1 hour before the close of polls, the first respondent reported through various public news media outlets the voter turnout around the country was fairly low and was at an average of 52% of the registered number of voters. On 10th of August 2022, at or about 13 hours, in his first media briefing to the public following the close of polling, their second respondent announced that the total voter turnout in the general election as captured in the electronic voter identification kits, that is the KIM kits, was 65.4%, equivalent to 14,466,779 voters. Roman 3, the second respondent, however, indicated that he expected the above number to rise once the number of votes identified manually was taken into account. Contrary to the above declaration and reasonable legitimate expectation, the final voter turnout captured and declared in the final results of the presidential election in Form 3C is stated to be 213,137 votes, which is absurdly lower and not higher as anticipated. Notwithstanding a computation using addition of the valid votes in figures for the presidential elections, candidates in the aggregate results shows that the total number of valid votes is 14,213,027. Now, my ladies and my lords, the first point that is being made there, that if you look at the results as announced by the Electoral Commission and what is stated in Form C as the turnout of voters, and that is 14,213,137 votes. If you compute or add the number of votes cast for each candidate individually, that is the petitioner, the second respondent, and the two other candidates, that the figure that results is not the figure that was stated in Form 34C. The figure is 14,213,037. That is the first point. And this is important because as we proceed, we are going to demonstrate that the number of voters who took part in the elections and the number of votes cast in the election is indeterminate and is a moving target. It keeps on shifting. And I invite your lordships and my ladies to look at the results as set out in Form 34C and I equally invite the court to calculate the number of votes garnered by each of the presidential candidates. The figures do not agree at all. And therefore, the first point of reference, as it were, is that the computation of the figure 50 plus 1 was based on a wrong computation of the total votes cast, as it were, and as proclaimed by the chairman of the Independent Elections and Boundaries Commission. Now, this may be a mathematical paradox or even a conundrum. The numbers of voters who turn out to vote, as declared by the Independent Electoral and Boundaries Commission, should be the same as the number of voters that are declared emanating from the KIM's kits, because the source of the number of voters that have cast their votes can be garnered in two ways: by looking at the numbers as recorded in the KIM kits, or at the end of the election exercise by computing the number of votes cast in the election. And my ladies and my lords, you would find that in this election, again, if you take the number of votes, or rather of the voter turnout, which was 65.4%, 65.4%, as against the number of registered voters in Kenya, that, my lords and my ladies, would give you the figure of those who turned out to vote. Because the percentage of the registered voters who are declared as having turned out to vote must be the same as the number of voters actually whose votes are counted as valid votes cast, and of course minus what are characterized as rejected votes. So, my lords, if you look at that particular point, and we're going to go through this one, you will find that the chairman of the Electoral Commission, in his announcement of the final results as borne out in Form 34C, and his announcement of the turnout of voters, which is recorded as at 65.4%, is at variance. And therefore, his calculation of the results based on the percentages cannot be correct. In this exercise, I invite you. In this exercise, I invite the court to look at the affidavit of one Edgar Ouko Otumba. That affidavit is two affidavits, a supplementary affidavit, and the first affidavit, which he filed on the 22nd of August. And my lords, in that affidavit, he makes a case, and Mr. Otumba has got a doctorate degree in applied statistics from Maseno University, and indeed he did assist this court in the previous petition in 2017. And he talks to the difficulties that confronts us in terms of the various announcements that the chairman of the Electoral Commission made. And he states that on the 9th of August 2022, the respondent issued a communique, that is on paragraph 10 of his affidavit, the day of the election, that the total voter turnout at 4 p.m. nationwide was at 56.17%. And that statement update is annexed to the affidavit sworn by the second petitioner, Madam Martha Karua. Then, at the close of the voting, the first respondent again issued a statement that the total number of voter turnout, based on the KIMS kit, was 65.4%, which culminates in a total of 14,466,779 votes. And that communique is borne out in the affidavit again of the second petitioner. In an affidavit that is sworn on behalf of the petitioners, first and second petitioners, Mr. Nyangasi Oduo In his affidavit, he talks to the Form 34C, and I'd referred to this earlier, where the total number of vote cast is 14,213,000. Now, the same Mr. Edgar Otumba saw a supplementary affidavit on the I think this affidavit was sworn on just a minute. On the 20th of August 2002. And I invite you, my ladies and your lordships, to look at this affidavit, because it analyzes several scenarios, including scenarios where the rejected votes are not computed, and scenarios where the declaration made by the chairman of the Electoral Commission as to the manual votes which were cast, which were recorded 86,889, and where those votes recorded as manual votes are computed together with the votes that were transmitted electronically. And then scenarios that would include the constituencies where the votes were declared later, including Elder's constituency. Now, the central point, and I want to make this point again, that the case that we are trying to make out is that if you look at the declaration made by the chairman as to the voter turnout, that will give you, as a percentage of the total number of registered voters, it will give you the number of voters that turned out to vote in the election, as opposed to another way of arriving at the same result, simply counting the number of voters that were recorded to have voted and cast their votes in the election. It is an equation that must agree in a mass submission. If the total number of voters that take part in the election do not agree with the votes that are counted as cast in accordance with Article 138(4), if they don't agree, then it means that the results of that election are not accurate, they're not transparent, and they're not accountable. And therefore, I'm inviting your ladyships and your lordship to go through this affidavit of Mr. Edgar Uko Otumba, because he lays out clearly there's several scenarios in which it is quite clear the second respondent, one William Samoei Ruto, could not have garnered 50% plus one of the vote cast in the election. And since all that is in our submissions and is in the two affidavits that are referred to, I invite your ladyships and your lordships to go through, and you find that it is indeed very compelling, the analysis given out by Dr. Edgar Otumba. Now, your ladyship and my lords, I'd also invite you to look at the affidavit of one Celestine Anyango Opio, and in that affidavit, which enumerates several constituencies including Chepalungu and many others, where in terms of the results as transmitted to the public portal, there was a systematic deduction of the votes cast for the first petitioner. And the same number of votes that were deducted from the petitioner were added to the votes of the second respondent. And the unique thing about this scheme is that the number of votes cast, the total number of votes cast, remained the same. The difference only was to the extent that the same number of votes that was deducted from the petitioner were given to the second respondent. And I leave that to your lordships to look through when you retire, because the Form 34 is in respect of those particular polling stations attached to the affidavit of Celestine Anyango Opio. There is also the affidavit, two affidavits from Arnold Ochieng Oginga, and this is particularly important because it contains discrepancies of the results in several areas and in voter turnout in Form 334C and the KIMS kit. And all this, my ladies and my lords, taken in totality, would affect the results of the elections. In paragraph 16, up to the end, he goes out analyzing areas where there were discrepancies. And you would notice, my lords and my ladies, that in totality, the discrepancies accounted for votes which are more than 140,000 votes. And in our submission, that has an impact on the result of the elections as declared. And I invite your lordships and my ladies to look at those particular analysis and annexures attached to the affidavit of Arnold Oginga. In the same way, in a further affidavit, Mr. Arnold Ochieng Oginga carries out an analysis in response to the responses to the petition by the respondents. And my lords, again, you would notice the number of votes that were being manipulated in order to secure a result that would favor the second respondent. And we have attached the relevant documentation, the forms showing the results, Form 34A's, 34B's, those particular forms. And finally, the Form 34B, which is a collation of votes at the constituency tallying centers. Now, my lords, I would conclude by saying that unlike many elections, this particular election, there was deceit, there was manipulation, and all this was premeditated and made possible by the attack, if I may put it that way, on the IT structure and system of the Electoral Commission. The way that the Commission was able to deal with the forms when uploaded, and downloaded, staged, transmitted, deleted, all this in totality. If you look at the case we put before you, my lords and my ladies, set out in the affidavits that I referred to, shows an election that was rigged in favor of the second respondent. And on that basis, my lords, we urge that you nullify the elections on the basis of the fact that the second respondent did not attain more than 50% plus one of the votes cast in the election. I thank you. I now invite Ms. Julie Soweto to deal with the second limb of our submissions.
Good morning, my ladies and my lords. I will deal with issue number 3, 4, and 5 as identified by the court, and that is whether there was a difference between Forms 34A uploaded on the IBC portal and the Forms 34A received at the National Tallying Center and Forms 34A issued to the agents at the polling stations. I will start with that issue. My ladies and my lords, the evidence that we supply for that issue is contained. First of all, the complaint is at paragraphs 81 to 91 of the petition, and the evidence is contained in the affidavits of Celestine Anyango, Arnold Ochieng Oginga, Benjamin Agina, and Benson Wesonga. My lady, in Celestine Anyango's affidavit, the complaint is made that in 41 forms from the polling stations that she looked at, the Forms 34A received by the petitioner's agents vis-a-vis the Forms 34A uploaded in the IBC portal and those brought to the tallying center are different. The sampled forms were from Bomet, Kiambu, and Kakamega counties. The evidence is at page 18 to 106 of the affidavit of Celestine Anyango. My ladies and my lords, this evidence should be considered together with the evidence in the affidavit of Benjamin Agina, sworn for the petitioner, paragraph 9. Which deals with the Forms 34A that the petitioner, the IEBC had stated it would procure, and the features in those forms that should have been used in the election. It is our contention that what the IEBC set out to procure is not what they procured in the first instance. Therefore, we cannot even match the forms that we have and that have been provided in the election to what they had set out to procure. We have stated in paragraph 110 of the petition, sorry, from paragraphs 108 to 110, that the IEBC procured 2 parallel sets of Forms 34A, marked booklets 1 of 2 and 2 of 2. It was intended that only booklet 1 of 2 would be used at the polling station, while booklet 2 of 2 was to be placed in a tamper-proof envelope and not to be used at the polling station. The forms that have been transmitted, of the forms that were used to transmit the results in this election 2022, do not meet the standards or conform to either of the forms that the IEBC said were going to be used, and this evidence is in the affidavit of Benjamin Agena. That is the first limb of the evidence that we submit through Celestine Anyango that shows the deliberate mischief in the use of the statutory forms that was set out in the election and which we now complain of. Going now to the evidence provided by Celestine Anyango in the 41 forms, what was observed is that the forms that the agents have and the forms in the portal are the same in all features. They have the same serial numbers. They are embossed using the same stamps. They're signed by the same agent, presiding and deputy presiding officers. However, the figures in the forms have been tampered with and are different with regards to the results for the first petitioner and the results of the first respondent, William Samoei Ruto. It is in the forms, or the sample of forms, the 41 sample of forms exhibited by Celestine Anyango, that votes have been reduced from the first petitioner and added to the first respondent. We have calculated the total number of votes reduced from the first petitioner and added to the first respondent, and they add up to 2,793 votes. My ladies and my lords, we contend that the figures are important because of the slim margin with which the first respondent won the election or was declared as the winner in the election. And the court, we asked the court to keep a note on that. My ladies and my lords, the difference between the result declared to overcome the 50% plus one threshold is 69,000 votes. 0.49%, which is the margin that the first respondent is said to have overcome the constitutional threshold, is the equivalent of 69,000 votes. And therefore, when we look at the results and the numbers that we will show have been tampered with, either reduced or removed from the first petitioner's votes, we will show that those discrepancies affect the outcome of the election or the result of the election. We have already shown that there is 2,793 votes removed from the first petitioner and added to the first respondent. There is also from Kakamega County the example where votes would be deducted from the first petitioner, but not added to any particular candidate. The mischief that is also borne out in our affidavits is that the intention was to ensure that the total number of voters remained exactly the same. So, for example, just a minute. I beg your pardon. At page 2 of the affidavit of Celestine Anyango's affidavit, at paragraph 4, my lady, just as an example, in Chepalungu, polling station 1 of 1, the first petitioners and the physical copy of